As introduced, R Gonzalez, representing the over 700,000 Hispanic-owned businesses in the state of Texas. You've heard the information, you've heard a lot of the data, you have it in front of you. I want to take it from a little different perspective. This is not only detrimental to our dreamers and our students and the Hispanic community, but it's the entire state of Texas. As stated earlier, we have a job shortage, we have a workforce shortage as it is. After COVID, there's a lot of our businesses that didn't survive. We now, in the current climate, have things of tariffs, what that's going to mean to small businesses. Small businesses are closing, and one of the biggest issues small businesses have today, or small and large business, is a workforce, an educated workforce. By passage of this bill, it is going to stymie and thwart some of those educated students and actually come out and provide a well-educated workforce to the state of Texas. In a previous life, I was very fortunate. I was the President and CEO of the United States Hispanic Chamber of Commerce. As I traveled around the country, one of the questions that asked me, JR, what makes Texas so successful? Why are they so doing well in business? And my answer was, because we have so many educated Latinos in Texas. That's what makes it work. Now, as many of you already know, Texas has been a majority state since 2014. The Hispanic population in Texas is the largest population. And a national study shows that between 2020 and 2030, the decade we're in now, over 78% of all new hires entering the workforce nationally will be of Hispanic origin. And as we look at it, it makes no sense to go ahead and use what I consider not defensive or not too, these are punitive. These are punitive marks. I mean, the goal line has been set. It's 10, it's goal to goal. You're inside the goal line, and then you move the goal line and triple the price. It's just not the right way to do things. And as Juan Carlos said, President Trump has also come to the conclusion that this country cannot operate successfully and sustain itself without immigrants. And for us to do it well, we need educated immigrants.
Thank you very much.
Thank you.
I'm sorry, one moment.
Of course.
I'm having to say, as a reminder, as the chair advises that the rules of the House strictly prohibit demonstrations or outbursts from visitors in the audience, including apparently snapping your fingers or clicking or whatever. So I'm advising you now, and I would appreciate, thank you very much. Go ahead.
Thank you. Good evening, Chair and committee members. My name is Crystal Gomez. I'm an immigration attorney with 15 years of experience representing immigrant families across our state, and I'm here to respectfully oppose the committee substitute for HB 232. Since I'm an immigration attorney, I'm going to focus this testimony on immigration law and how this bill conflicts and excludes countless immigrants who have lawful presence in the United States. They, through no fault of their own and due to the complexities of federal immigration law, either don't yet or may never qualify to apply for lawful permanent residence despite years or even decades of authorized residence in Texas. I have represented hundreds of these young Texans that would be harmed by this legislation. DACA recipients who've been vetted by the federal government, work legally, pay taxes, contribute to our communities, yet have no statutory pathway to permanent residence under current federal law. Family of military members, survivors of crime and domestic violence or persecution, with pending applications that might take more than 10 years for adjudication, all while they lawfully reside in Texas. All of these individuals can be lawfully present for extended periods, sometimes their entire lives, without qualifying for permanent residency. What deeply concerns me as an attorney is what Ms. Etter was testifying to a bit ago, is that in this committee substitute, since we hinge eligibility for in-state tuition on a pending application for permanent residence, and so many people are not qualified for that we're going to place these young 18-year-olds into a position where they apply for a benefit that they are not eligible for in order to qualify for in-state tuition and be able to afford college. And if that happens, they're in a very precarious position. Not only are they going to be out the thousands, sometimes upwards of $3,000, $4,000 in application fees that these permanent residence applications cost, but they're also putting themselves at risk of getting put into deportation proceedings, as Ms. Etter testified to under this new February memo that USCIS has put into place. So additionally, as you've heard tonight, immigration status isn't static. Today's Texas DREAM Act beneficiary will become tomorrow's legal permanent resident or U.S. citizen able to work lawfully in the U.S. Several of my clients who were educated in Texas thanks to the DREAM Act have worked right here in this building as legislative staff, contributing to their talents, insights, and hard work to this state. They're now legal permanent residents, citizens, but some, as you've heard, are still stuck renewing their DACA every 2 years because the federal government has failed to fix our broken immigration system for decades. Texas can do better than this bill, and I urge you to reject Committee Substitute 232.
Thank you. Members, any questions for this panel? Representative Ward Johnson. Oh, excuse me. Representative Davis.
Thank you. I want to circle back to something you were just talking about, students becoming legal permanent residents. So does this bill allow for students who are in that process to pay the in-state tuition?
Yes, so the committee substitute does. It says essentially either you're younger than 17 and you can use the affidavit process that we've always had or had since 20 some odd years, or you're over 18 but you can show that you've applied for permanent residence, and those are the only ways to qualify. So if someone is over 18, I can see a world in which they enter an application for permanent residence that they may not qualify for, because it's not like you can wake up one morning and decide to become a permanent resident of the United States. And if they do that, they're in real trouble.
What are some of the costs associated with that application for permanent residency?
If somebody is applying straight, like there's no complicated factors, it's about $3,005 for the work permit, for the application for permanent residency, for travel permission. If a person is paying a fee because they qualify in these minute kinds of law, they have these additional fees, another $1,000. So some folks do pay about $4,000 or so.
And this is what an 18-year-old would have to pay.
Right.
All right.
In addition to attorney's fees, if they find an attorney who can help them. Hopefully they do, so that they don't submit applications that they're not qualified for.
Okay, thank you.
Yeah, of course.
Chairman Wilson.
Yes. Thank you. Appreciate your testimony
Yeah, of
today.
course.
And is it Ms. Etter?
Yes.
Yes, it's for the two law councils. Both of y'all stated that they may not be eligible yet.
Chairman, your mic.
There we go. Can you hear me now? Great. Both of y'all stated, paraphrasing, that they may not be eligible yet. Can you expand on that? What would make them not eligible to apply?
Do you want me to take it?
If they're a student enrolled, go ahead.
To be eligible for permanent residence, you have to be able to fall into a very set of categories. And so there are a lot of folks who aren't in that set of categories. For instance, in the family-based world, you have to have a sponsor or somebody who can petition for you that's already a U.S. citizen or permanent resident, that is a parent, a child over 21, or a spouse. So those are the only folks who can, and that you entered lawfully to the country. So if you didn't hit those, if you don't have parents who are citizens or permanent residents who can't petition for you, you're out of luck. There is no path. You can't apply for residency.
I see. And let me ask you, have y'all seen the affidavit that they signed?
Yes.
What does it say?
I believe that it says that you're attesting that you will apply for permanent residence when you are eligible to do so.
When you are eligible to
Right.
do so. Right. And you just basically stated that eligibility may not ever be there simply because
If our Republican-controlled
they're
Congress
not
can't
there.
pass immigration
Right.
reform, then yes.
Okay, thank you very much.
You're welcome.
Representative Ward Johnson.
How long does it normally take?
May I say
Oh,
one
no,
thing?
you're good.
Why would they sign that affidavit if they know that there is no pathway to be eligible?
Because the affidavit doesn't say that you are currently eligible and that you will file an application. It says if and when you're eligible to do so. And
But if
there
they
is
know-
a world in which
if they know that they will not ever be eligible because of that one point, why would they sign the affidavit?
As I testified to a bit ago, immigration status isn't static. So you may not be eligible right now, But you go to college and you meet the love of your life who happens to be a U.S. citizen, and now they can petition for
Fair.
you after you get married,
Yeah.
and now you can. So
No,
things change, life
No,
changes.
No, great. Thank you. Ma'am, did you want to add something?
No, I was just going to say that very thing. I mean, I think, again, I wish it were that easy. I wish you could just wake up and say, I want to apply to become a lawful permanent resident today. And if we had immigration laws that had kept up to date and that made sense, that would be a great thing. But that percentage is so low, and I think that maybe that might be one of the misperceptions of the bill, is that there are all these people out there that are eligible that are just too lazy to apply. And I can guarantee that that is not the case. If you were eligible to become a lawful permanent resident, you would have applied, and not just to receive in-state tuition, just for all of the other benefits that would confer.
Thank you.
So, thank you.
Representative Ward Johnson, back to you. Thank you.
Yeah, you kind of asked my question, but just to follow up, how long does it take to when she put the application in to become a?
So that also depends on how you're applying for permanent residence. So in best case scenario, you entered with a visa and you marry somebody who's a citizen and they apply for you. It's taking about a year and a half. Roundabouts. Now, if the worst case scenario, or if a permanent resident is the one who's petitioning for you, that can take years, 5, 10, 20 years.
Right, because we're not saying 17-year-olds should go out and get married.
Right, right.
Okay, thank you.
Representative Tinderholt?
Thank you, ma'am. Crystal. You're Crystal,
Yes.
right? Okay, thank you. Thank you for being here today.
Sure, of
You
course.
mentioned February, you mentioned CIS, and you mentioned the affidavit. Can you explain that again? Having them fill out the affidavit, and you said filling it out creates concerns.
Yes. So February 28th, USCIS put out a memo saying that they were instituting an NTA policy, which means prior to February 28th, if you applied for a benefit through USCIS, residency, parole, something, and you were denied, U visa, VAWA, they would just deny you. You'd be out that money and that was it. Since February 28th, under this new memo, if you're denied and you're not lawfully in the country, they automatically refer you to ICE. So, or not lawfully, if you're not lawfully present, they'll automatically refer you to ICE. And so then you get put into deportation proceedings. And so my concern here is that an 18-year-old who doesn't know any better files for a petition or an application they're not eligible for, gets denied, and automatically gets referred to ICE for deportation proceedings.
So if that's the law and they are here illegally, are we or are you not subverting the law by basically saying that, by saying, hey, don't fill this out because they'll find out that you're here, and so then they will put you on this list?
I think encouraging immigration fraud is probably worse than telling people not to fill out an application that they don't qualify for. If an application exists and it has eligibility requirements, I'm not going to tell somebody as an immigration attorney to go fill out something they're not qualified for. That's fraud.
But on the other side, we're also telling them not to fill it out so that they don't go on the list. I think you can look at it for two different ways. And so I want people to think both ways, not just one direction, because immigration is trying to clean up the system. And I know that at the federal level that this has been an issue for a long time, but right now the law is the law the way it is, unless or until it's fixed. And so I just want to be careful with how we talk about what we're doing.
Representative Tinderholt, would you mind if I just commented to your
Absolutely.
concern? Okay, so I appreciate that concern. I want to make it clear, though, that the way that the bill is written, you can be lawfully present but not eligible for lawful permanent resident status. So let me give you an example. You could be here on some type of work authorization or other lawful presence and not be subject to deportation proceedings, yet then file an application for lawful permanent resident status and be denied and then thrown into deportation proceedings as a result of your application. So what I'm saying is a person could be here totally fine, lawfully, and have no issues, not be subject to deportation. And it's just the filing that could trigger the deportation proceedings. And the filing is what we're concerned about, that is encouraged or, required in the bill.
Well, I think we have to have some sort of way for them to get this benefit if this bill were to pass. It's either that or they have to be a legal individual. And so I think you have to balance, do you want the benefit or do you want to be a legal resident and those are the only people that get it? Am I wrong?
Well, I think, again, you can be lawfully, so because the bill requires that you apply for lawful permanent residence, yet there are so many other ways that you can be lawfully present but not a lawful permanent resident. So the bill encourages or requires that you file for the lawful permanent residency to be eligible. So I see what you're saying, but again, this is a policy we've had since 2001, and it's worked very well. It's caused Texas to be able to recoup billions of dollars in the investment that they've made in these students.
Okay, thank you.
Thank you so much.
Any other questions? Representative Perez?
And this is the major problem with the bill, and so it has to be explained. I mean, we have to all be very clear on this. I mean, one of the other big problems too is Congress, right? I mean, so it is Congress's failure to act on immigration why it is these students are in a legal limbo, and what this bill is doing is that it is forcing them to start a process, and it is starting an enforcement process on students that have no alternative right now because of Congress. And so that's why I'm failing to see the Texas enforcement component without this congressional action. But that is the problem, where you are now requiring colleges to act as these quasi enforcement institutions, and you're requiring them to kind of almost report or have this mechanism on students that have no means right now because of the failures at the congressional level. And it is just a very flawed bill to make students go through that process. So if you can just kind of talk about that a little bit more, because that is, to me, the biggest issue with this bill, is you are forcing students who have currently no option. Again, they might fill the affidavit out, and again, with the hope that Congress acts soon, and yes, they are eligible, they will apply as soon as Congress acts, right? I mean, so if you can just touch on that a little bit more.
Yeah. Yeah, well, I think that's why the current law makes sense, is because it anticipates that one day we would have comprehensive immigration reform. One day you'll be eligible either through that reform or, as Ms. Gomez mentioned, through marrying a U.S. citizen or having an adult relative that can petition on your behalf down the road or whatnot. But I think, you hit the nail right on the head. And I think that's why the current policy makes sense, because so much of what is in the federal government is out of our control.
Right. And that's why, from a Texas point of view, it's just sort of like, hey, well, this is the federal government's problem. We're going to, we have people here in our state. We need to educate them. If they're not educated, it costs our state. So it's a win-win for us until the federal government gets their act together. But this changes that whole formula.
And Representative, may I point you again to President Trump's comments from December saying that Dreamers are successful, they're business owners, and I quote, "I want a solution for the Dreamers." So why not wait until the federal government, until President Trump and this Congress does something about this issue? And he said this twice. He said on Fox Noticias, and I quote, "We will allow farm workers and hotel workers to stay a little while, and if employers can find a way to sponsor them, we will be able to have them have a legal status." So we have to wait for the federal government and urge our federal lawmakers to address the issue once and for all.
Right. Because, during earlier remarks and from several members of the committee, there was a comment made that it's about personal responsibility, that we want to ensure that students are following through and ultimately getting the legal status. But again, you're expecting something that's just currently not possible, and you're setting up all the students for failure. And I just want that to be clear, that there isn't going to be any student who's going to be able to meet this eligibility criteria that Texas is now setting up, right?
Yeah.
Thank you.
Thank you.
Chairman Wilson?
Thank you so much. In this bill, anywhere do you see where it requires the institution to report?
No, I did not see a reporting requirement, which is why I think it also creates a kind of an unworkable policy because it's not time limited. It's essentially if any student applies for LPR status and is at any time of their lives is denied, then they're going to have to repay the difference of in-state tuition. And I don't know how colleges would track that.
Right. Okay, thank you.
Thank you.
Any other questions? Thank you all very much.
Thank you all so
Thank you.
much.
Thank you for your time.